I'm going to tell you 3 reasons that your case may be worthless if your family member was killed in a car accident, and we are starting right now. I'm Justin from justinziegler.net. The first reason why your case may be worthless if a family member was tragically killed in a car accident is that there may be no insurance coverage available. We see on the news and see on the internet huge verdicts for people that are killed in accidents. However, oftentimes the at-fault driver has no bodily injury liability insurance available. That's the insurance that pays for your pain and suffering if a family member is killed in a car accident. In Florida, where I'm a wrongful death lawyer, most drivers do not have to have any bodily injury liability insurance on their car. Now, if you're hit by a corporate defendant like Walmart or a Target truck or a public supermarket truck, insurance doesn't matter. However, if you're hit by your average driver, many drivers do not have enough insurance to pay for the value of a wrongful death case. Now, just because the at-fault driver or owner of the car had no bodily injury liability insurance, you may still have a claim if the person who was killed, the decedent, had uninsured motorist insurance on his car or lived with relatives who had uninsured motorist insurance on their cars. That uninsured motorist insurance may pay for your mental pain and suffering. And if the decedent was driving a car and didn't have insurance on it, the family members are not going to be entitled to Florida's $5,000 PIP death benefit. When calculating the value of a case if a family member is killed in an accident, many wrongful death attorneys start backwards. Before even finding out how the accident happened, they look for insurance coverage, because if there's no insurance to pay for the pain and suffering aspect of the claim may be worthless. The second reason why your case may be worthless if a family member is killed in an accident is because you may not be a survivor under the state's wrongful death law. For example, in Florida, there is a law that says which family members can make a claim for mental pain and suffering if a family member is killed in a car accident. To make a claim for mental pain and suffering, the other driver or someone else has to have been careless. I'm focusing on mental pain and suffering because that is typically the part of the claim that is worth much more than the loss of the decedent's ability to earn money in the future. Again, decedent is the person who was killed in the accident. And mental pain and suffering damages are typically worth a lot more than the loss of services and support that the decedent provided to the family members. The two classes of family members that are always entitled to money for pain and suffering, if they can prove someone else was at fault, are minor children and the spouse. Now, minor children in Florida wrongful death case is defined as a child who is under the age of 25. And the parent is always entitled to mental pain and suffering if their minor child is killed in a car accident. If an adult child's parent is killed in a car accident in Florida, he or she can only get money for mental pain and suffering if the parent was not married at the time of death. And Florida defines an adult child for the wrongful death law as someone who's 25 years or older. So if an adult child's parent was married at the time of their death, the adult child cannot get 1 penny or more for the pain and suffering of their parent being killed in a car accident. And the parent can get money for mental pain and suffering if their adult child is killed in a car accident only if the adult child was not married and did not have any kids at the time of the accident. The third situation where you may not be able to get any money if your family member was killed in an accident is if no one else was responsible for the accident. In other words, if your family member was 100% at fault. Instances like your family member walking in the middle of the street, not in a crosswalk when it's pitch black and the driver had no time to see him, may mean that your family member is 100% at fault and you may be entitled to nothing. Now, if your family member was partially at fault for causing the accident, in a state like Florida, the value of the case is reduced by your family member's percentage of fault. So if your family member was 60% at fault, the full value of the case is cut down by 60%. The pain and suffering component of a wrongful death claim can be very large, so even if the case is discounted by 10% or 20% or 30%, the settlement value of the case can still be very large. Now, if your family member was killed in a car accident and the police officer blamed your family member for causing the accident, the police officer may be wrong. You may still have a large case. Although fault is very important in a wrongful death case, when I get a call from a potential client whose family member was killed in an accident, I start backwards. I look for insurance coverage or a collectible defendant, such as a large corporation, and then I make sure that the caller, the person who's calling me, is a survivor under Florida's wrongful death law. In order to settle a wrongful death case, a probate estate needs to get set up. You want to hire a probate attorney to do this. If you hire a wrongful death lawyer, he or she can help find you a probate attorney who will wait to get paid for setting up the estate until the end of the case. To learn how to get the largest settlement in the shortest amount of time, watch these videos here. Thank you. Subscribe to my channel, turn on the notifications bell so you don't miss any future videos, and I will see you in the next one.